Association. Tout d'abord, merci à tous de nous avoir rejoints pour notre événement parallèle. Les interlocuteurs et intervenants d'aujourd'hui parleront en anglais, mais c'est important pour nous que nous puissions répondre à vos questions en français si besoin est, ou revenir sur des parties des présentations en français. Donc, soit par mon biais, soit par le biais de Dov Jacobs, on sera tout à fait en mesure de poursuivre notre discussion en français si besoin est. Et nous espérons qu'à l'avenir, nous pourrons assurer des traductions simultanées. Nous y travaillons puisqu'il est très important pour nous qu'on puisse travailler de manière équivalente, tant en français qu'en anglais. Et merci encore de nous avoir rejoints sur des questions aussi importantes que le rôle du conseil pendant les examens préliminaires. So I'll switch to English now. I just mentioned that we will be able to take questions at the end of the discussion, both in French and English, and we have the ambition to make sure that we'll have interpretation from French to English and from English to French in the future. So welcome to this side event about the importance of the role of counsel for defense and for victims to ensure the efficiency and transparency of preliminary examinations at the ICC. Our discussion will cover different topics: cooperation, representation, and outreach. I think it's important for us that we can discuss this topic because usually during preliminary examination, the impression that we get is that the most important role goes to the prosecutor. But as an association that is the voice of counsel and so many different counsels, victims counsel, defense counsel, but also counsel for state, counsel that act as amicus curiae, for example. And all of us in our different capacities have very important roles to play during this preliminary examination. So that's why it's so important for us to organize these events and to actually present to you what we do, but also to initiate a conversation about it. So we hope that these conversations will be very fruitful and that it will be a starting point to maybe some work of our institution on these topics. I also wanted to mention that if we want to discuss in the time that we will have left after the presentations, other topics that we work on as an ICCBA, we'll be also really happy to discuss that. For example, we are working a lot on gender issues, for example, and there might be questions also for the funds to organize family visits for detainees or cooperation to concerning sentencing and things like that. All these topics that were addressed during the ASP could also be addressed here. So without further ado, I will start with our first speaker of today, that is Heidi Dijkstal. We're very happy that she accepted to participate to this event. Heidi is a UK barrister and a US attorney with over a decade of experience practicing international criminal and human rights law before international, regional, and domestic courts. Her practice has included work before the ICC, the ICTY, the SCLSL, African Commission and Court on Human and People's Rights, and the UN Working Group on Arbitrary Detention. Heidi has been a member of legal teams before the ICC since 2011 and representing parties including the defense, victims, and governments. This includes the defense team for Abdullah al-Senussi, legal teams for Sudanese victims, legal team for the Kenyan government, and recently as co-counsel for victims of the Gaza Freedom Flotilla, as well as for the government of the Comoros in registered vessel situation. She currently acts as counsel for a group of victims in Afghanistan situation before the ICC and is involved in the legal team representing Palestinian victims before the court. So Heidi, the floor is yours.
Thank you, Jennifer, and good morning, good afternoon, good evening to everyone wherever you're joining us from. I'm very glad to be part of this discussion on the role of counsel in the early stages of the proceedings before the ICC, and particularly given that today is Human Rights Day, and so many of the issues touch on important human rights, such as the right to truth and a remedy for victims, and fair trial and due process rights for the defense. I'll be addressing the role of counsel for victims of crimes within the jurisdiction of the court and how counsel assist in their participation in the early phases of proceedings. In order to highlight the role that the legal representatives for victims play during preliminary examinations and investigations, I think it's important to highlight the ways in which victims participate during these proceedings and why the participation of victims at the early stages is so important. As we know, the preliminary examination phase and even the investigation stage is a time period when a lot of the tasks that we're aware of and the activities in a situation that need to be analyzed and examined are with the Office of the Prosecutor internally. And the instances whereby the parties are litigating before the chamber are more limited, but certainly not less important, and I'll come back to that later. At this stage, the question is, how do victims fit into this phase in the proceedings? How do they participate? Why is it important? And how do counsel assist? I think the key issue in the mind of counsel for victims regards the ability of each victim to get justice for the specific harm they suffered before the court. And it's important to understand that the preliminary examination and the investigation stage are critical time periods when this matter is being determined for each individual victim seeking to participate before the court. To have the harm against them in particular considered and to seek justice for what has happened to them. We must remember that during the preliminary examination phase, the prosecution is evaluating whether, based on the evidence before it at that time, there's a reasonable basis to believe that crimes within the court's jurisdiction have been committed that warrant an investigation. And if the situation proceeds to an investigation, the scope of the investigation is formulated and the prosecution is deciding how and where to allocate its not unlimited resources. As we well know, preliminary examinations, investigations can last years. And during this lengthy period, the situation is being internally and confidentially examined by the Office of the Prosecutor. While we understand that this length is often due to the massive task of examining all the information to try to bring the strongest case possible, while also engaging in the important dialogues of complementarity with states that underpin the court, for individual victims, this lengthy process can seem opaque and unclear, creating transparency as to the process being undertaken during the early stages of the proceedings and over a long period should, of course, be a priority for the prosecution and other parts of the court, such as VPRS and outreach. But victims' counsel also play an important role in this as well, particularly by guiding victims in how they can best participate and engage with the court. Whether counsel is representing one victim, a group of victims, or a large number of victims, ensuring that the facts of what happened to each of these clients is before the prosecution during these very early stages of the proceedings, so that their fact patterns and its supporting evidence form part of what's being analyzed during these early phases and gives a chance of being the basis for a case brought by the prosecutor is of critical importance to the victims. Remember that under the rules of the court, a victim's application to participate will be reviewed to ensure that the harm that they suffered fits within the scope of the crimes for which the prosecution is examining. And therefore, the scope of the prosecution's examination and investigation as it tightens is key, because only those victims whose harm fits within that scope as it becomes more limited can continue participating before the court and giving them a chance at getting justice or possibly even reparations. In many of the situations before the court regarding conflicts, which are widespread within a state or over multiple states, and over the course of many years, there could be a multitude of crimes which fall under the jurisdiction of the court, yet there are often only a few accused charged, and only for those crimes which are attributed to that particular person. So simply put, if the victim do not have assistance in highlighting the specific crimes for which they have been harmed and have the opportunity to tell their story and provide any evidence to the prosecution, how can it be expected or ensured that the prosecution, with all that there is to do and analyze and examine during these early phases of the proceedings, will dedicate time and resources to potentially bringing forward the specific crimes against your clients and including them within the scope of each progressive phase of the proceedings? So here I look to the OTP's policy on case selection and prioritization, which promotes direct interaction with victims and victims' associations at all stages of the proceedings. And I also look to the function of Article 15 submissions to the Office of the Prosecutor, which allow victims, victims groups, and individuals to make direct submissions to the OTP with evidence about the crimes against them, and these are ways in which counsel can assist at these stages of the proceedings to make sure that their client's case has the chance of being brought forward. I also want to address the victim's ability to participate as a party to the proceedings arising before the court. So what I just addressed was the victim's ability to speak to the prosecutor and to try to have some influence over what is happening in that internal process with the Office of the Prosecutor. But another aspect of victim participation that's so important during these early phases, such as the preliminary examination phase, is when proceedings come before the judges and whether the victims have a chance to speak directly to the judges in these proceedings. As we know, Article 68 of the statute sets out that the court shall permit the victims to communicate their views and concerns to the court when their personal interests have been affected. The case law before the court has repeatedly affirmed victims' ability to participate as parties to the proceedings as early as the preliminary examination phase and into the investigation stage. For example, challenges into whether an investigation will be opened. I think here of the Article 15 proceedings in the Afghanistan situation, or the judicial review proceedings by the government of the Comoros. Here, the victims were a party to the proceedings. Victims participated in proceedings to answer the question of the scope of the court's territorial jurisdiction in the situation of Palestine. Again, key to the victim's interests, because whether the scope was larger or smaller would either exclude or include some victims. And victims have regularly participated in admissibility proceedings also as parties to the proceedings. This is just to name a few ways in which they have directly participated and communicated their interests in the ongoing proceedings. Each of these proceedings, whether to open an investigation on the scope of the court's jurisdiction, whether it's admissibility or judicial review, are critical to whether or not a victim's harm will be or won't be addressed before the court, and therefore seriously affects their interests and whether they have the chance of getting justice. Importantly, this is done through victims' counsel. And to this, I want to reiterate that while not absolute, victims have the right to choose their counsel and act through their own counsel. And this has been confirmed by the court. With this, I do pause with concern as to recent developments, for example, in the Afghanistan situation, whereby victims' views and concerns through counsel as to the Article 18 proceedings on restarting the investigation and the prosecution's prioritization within the investigation have, when victims have made submissions recently, they have been deemed to have no standing. and a system has been suggested by the Chamber whereby victims' views are communicated through reports from VPRS. I raise this example to highlight that we must remember that victims' views do not always align. They have different backgrounds, different experiences, different harms, different motivations before the court. They can't be sufficiently represented in just one report without conflict. It should also be remembered that it is the legal representative of victims and their teams who spend the many years of these lengthy proceedings, as we mentioned before, continuously working with the victims, getting to know them, and building trust. Taking evidence of what's happened to them, advising them, guiding them through the entire process. And importantly, hearing their worries and anxieties and fears, and also their hopes of what can be achieved before the court. These years of communication and building a relationship and trust with the victims, many of whom have been severely harmed and traumatized, and whose security needs are best understood by the legal teams who work with them over years and years and understand their situations. It allows counsel to put before the court this experience that counsel has, getting to know these victims. It allows them to put before the court the strongest case on both the law and also the personal aspects of their thoughts and concerns and their security needs before the court. So I'll end there. These are the aspects that I think are important to emphasize in these early phases, particularly the preliminary examination phase. But I'm happy to take some questions when we do that. Thank you.
Thank you, Heidi, and thank you for your very complete presentation and for already giving us guidelines for the discussion. First, the different ways that victims can play a role in during the PE, be it by cooperating with the OTP. That's what you describe as influence, by using also legal tools and discussing admissibility and having a more proactive or active role, and also for highlighting where we maybe need to improve, because we have always noticed that VPRS and the registry has a role to play, but that role cannot be to supplement the work of counsel that, of course, developed relationship with their clients. So thank you for that, and it was very interesting, and I'm sure there will be many questions. So after hearing the victims, we would like to hear about the defense views, and for that we have Dr. Jacobs. The floor is yours.
Thank you, Jennifer. Hello, everyone. It's a pleasure to be part of this really important side event and a very important issue. We all know, and we've all been following in recent years, how discussions on preliminary examinations have been at the center of attention, from outside observers to the room, to the work of the ICC. So in that context, it's quite important that the ICCBA brings its contribution. And as Jennifer said, we represent every protagonist in a PE, potential PE. So it's important that we can bring our experience to the table on this important discussion. Now, there's a lot that could be said, but interestingly, when I've been discussing those matters for years now, including with some people that are present in this meeting, and the initial reaction I get when I discuss the role of the accused or potential accused during a preliminary examination, the instinctive reaction is, well, there's no accused during a preliminary examination, right? We're just looking at the global situation. We're not looking at any accused. There is no role. I mean, if you listen to Heidi, it's the role of the victims is very important from the start, and it makes sense. I mean, we listen to Aidan with the states as well, but it's true that the natural instinct, when you just simply read the Rome Statute, is to say there is no role for the accused or potential accused or suspects during the preliminary examination. And I would argue that that's a mistake to approach it in this way, for a number of reasons, which I'm going to present briefly because I don't want to speak too long and leave some room for the discussion. But the first reason is it's artificial, even though the preliminary examination is obviously not a formal investigation, it would be artificial not to see the different phases of the prosecutor's work as a continuum. Obviously, the work done during the preliminary examination will be the foundation for what will be done during the formal investigation, will be the foundation of what will be done, in the case phase, etc., etc. And sorry for the probably unoriginal metaphor, but it's like building a house. If the foundation will be the PE, and my view, which is shared by many, I'm sure, is that if the PE starts on a bad basis, a bad foundation, it could affect the whole investigation and cases that would come later. So one cannot separate the PE in this sense, and this also applies to potential suspects or accused. Is that even though it's not a formal investigation, the prosecution, you cannot artificially distinguish finding information about crimes committed, about victims, but just ignoring because it's putting a kind of a block that it's not important at this phase, not looking at suspects. You're going to look at suspects. You're going to hear about suspects. You're going to find evidence about suspects or potential suspects. The victims are going to tell you about potential perpetrators. You can't just ignore that you're going to receive that information, and there has to be something must be done with it. And we have to acknowledge that this is part even of the preliminary examination. So even if you look at the decisions or the requests that are filed by the prosecutor to open formal investigations, I won't go into the details of those requests, but there is a diversity of practices from the OTP, but they always refer to alleged perpetrators either as groups, sometimes as individuals in some cases, that the prosecutor has already identified in requests to open investigations specific individuals, but perpetrators are always there, if only because the admissibility of the situation has to be evaluated. And I won't go into detail of the case law, for example, in the Kenya situation or other situations where there is a discussion about the admissibility, and the admissibility relates to the potential crimes and the potential perpetrators. So even during the preliminary examination phase, even if it's just a prima facie evaluation, the prosecutor is going to look into potential perpetrators, if only to satisfy the admissibility criteria. Another reason why it's going to be taken into account in that phase is, again, the duty of the prosecutor to investigate under Article 54, both incriminating and exonerating evidence. And I insist, even if it's not a formal investigation, the state of mind remains the same. As early on as the preliminary examination, the prosecutor has to keep in mind its obligation to investigate both kinds of evidence and gather it, because later on there will be an obligation on the part of the prosecutor during the investigation, and especially during the case phase, to disclose such evidence to the defense. So if the accused is not kept in mind, and when I say the accused in this sense, it's investigating both sides of the conflict immediately, because the defense will be given access very much later in the process, the prosecutor will fail both in its obligation to investigate exonerating evidence and would be failing its obligation to disclose later. So the state of mind of taking into account the accused must be on the table from the very start. One other aspect is procedural issues, and I like Heidi, it's difficult to just stick formally to the P and not look further. But until the case phase, there is this idea that the accused is not there. So the request to grant an arrest warrant will be ex parte without the accused. A number of issues will be discussed without the counsel being there, and that's problematic. So obviously, there are several ways around this problem, because you can't just appoint a lawyer for the accused without an accused. One way of dealing with this is to reserve the right of future defendants to raise the issue again. And Heidi mentioned the jurisdictional questions in Palestine. The pretrial chamber actually made it very clear that it was for this phase of the proceedings. and a number of amicus curiae raised the issue that it was important not to limit the rights of a specific accused in the future to challenge jurisdiction. And that's one way of dealing with it. But it's important to keep in mind that no early decision, which is ex parte without the presence of a defense counsel, can be definitive by definition. It will affect the future, whether it's admissibility, whether it's jurisdiction, whether it's arrest warrant, which is a basis for detention. It should and can be challenged later on. All of these early procedural decisions can be revisited later on. Now, one can go even further than looking at the various ways the accused directly or indirectly is taken into account, is actually thinking of putting in place a framework by which a prosecutor would approach potential suspects or accused during the preliminary examination, the same way that he would approach victims, and the same way that he would approach, his obligation to investigate or to pre-investigate during a preliminary examination all sides of the conflict. There is no reason to, per se exclude the possibility, and obviously it would have to be looked at in a case-by-case basis, where the prosecutor would approach a potential suspect or someone he might think is involved, or someone who might have relevant information about one side of the conflict rather than the other. And I think that would increase the credibility of preliminary examinations if it were established, from an early phase. It might be confidential contacts, of course, for various reasons, but that the prosecutor has made an effort to hear, you would say in the American criminal law, person of interest, but to hear someone who might be linked to the investigation or to the preliminary examination in some way or other. And to hear them, their counsel might have information to bring to the OTP, might have exonerating evidence, might have any kind of information that might actually be useful. When you look at Article 15, it says that the prosecutor can refer to any relevant information from any reliable sources. It doesn't mention potential accused, but or potential person of interest, but there's no reason to exclude it. So maybe the counsel might be willing to cooperate with the OTP, bring other evidence which might be taken into account, and that would increase both the quality of the preliminary examination, but also the credibility of it in terms of neutrality and objectivity. I think I'm reaching the end of my time, and I've covered most what I wanted to say in those 10 minutes. So I'll stop here and look forward to any questions.
Thank you so much, Dov. And I realized that I forgot to give a little bit more on your bio. Of course, this is because you do not need any introduction, but I will still give some information that next to being a professor, having a successful blog that is of interest of all of us, that is called Spreading the Gem. You're also an international law and international criminal law expert. You're a defense counsel at the ICC and at the MICT, and you're the founder of SILK, Strategic International Legal Consulting. And amongst other current engagement, you're currently co-counsel for Mr. Said, and you are on the defense team of Laurent Gbagbo at the ICC, and on the defense team of Félicien Kabuga at the MICT, as well as duty counsel for Yoyich at the Mechanism. And you've also been involved as amicus curiae in both the Afghanistan and Palestine situation at the ICC. I think this information is also important for the conversation that we'll have afterwards, that you know a little bit what is the expertise of our speakers today. Thank you so much for highlighting the role of the defense that might not have been so obvious before your presentation. It's interesting to see that indeed, since the very beginning of the proceedings and the PE incriminating and exculpatory evidence must be considered. And thank you for giving the different ways that the defense could actually play an active role in the PE. So after hearing about participants, or future participants, and their important role during a PE, to the proceedings, we cannot forget about states. And Aidan Ellis, you will tell us a little bit more about that. Aidan has worked for defense teams at the ICC and at the ICTY for the last 9 years. He practices as a barrister in London and The Hague. He's currently counsel for the defense of Saif al-Islam Gaddafi in the admissibility proceedings at the ICC. He has previously worked for the defense team representing Saleh Gerbo and Banda in a situation in Sudan. And he was the editorial assistant on the latest edition of the Archbold International Criminal Courts. He has previously served and chaired on the membership committee of the ADC ICT. And I'm sure I forgot more recent activities of your Aidan. If you want to supplement it or it comes across from your presentation, we'll be happy to hear it. The floor is yours.
Thank you. I'm grateful to have the opportunity to speak about the role that counsel play in representing states at these very early stages of ICC proceedings. Not least because this is particularly an area where the work that counsel do can be invisible, in the sense that if it's done well, a case might not reach a courtroom at all. In my experience, the interest of states typically relates to asserting and progressing their own national investigation of Rome Statute crimes. And it's worth recalling at the outset that pursuant to Article 53(1)(b) of the statute, a preliminary examination will only progress to the investigation phase if the cases that arise are likely to be admissible. And in very broad terms, they are only likely to be admissible if the state involved is unable or unwilling to investigate them genuinely itself. And as long ago as 2013, in a policy paper on preliminary examinations, the Office of the Prosecutor identified encouraging genuine national proceedings as one of the key goals of the preliminary examination process. So that's been a goal of the Office of the Prosecutor for a number of years now. And it was perhaps given fresh impetus and highlighted again in the inauguration remarks by Prosecutor Khan, who spoke very eloquently about the need to engage in novel and imaginative ways with states, and indeed to share the burden of these investigations with states. And we've seen some early examples of that in practice with the cooperation agreement being concluded with Colombia, which closes the very long preliminary examination in that case, and also the memorandum of understanding concluded with Venezuela. So this is, it seems to me, an area that's likely to grow in importance in the years to come. And I want to try and talk in a very practical way about the role that counsel can play on behalf of states and in assisting states. Looking in particular at three areas, those being engagement, setting up a benchmarking framework, and evidence. As to engagement, it seems to me that this is very much the base level for what counsel can do. It's where it all starts. It's already been remarked that these preliminary examinations may last for years. And of course, if they progress to investigation, they may go on for even longer than that. The ICC is to that extent capable of being a patient institution. And states engaging with it therefore need to be prepared to engage in correspondence and meetings at appropriate levels, both in The Hague and in the state concerned, over a period of potentially years. And the role of counsel there is to advise on those communications and those meetings, because although this is partly perhaps a diplomatic process, it's certainly a legal process. And it's particularly important that counsel are involved in drafting the written communications in these cases, because of course these are exactly the sort of communications that can end up being litigated in the courtroom if at some later point in time the genuineness of a national investigation is to be challenged. Those communications may turn out to be part of the evidence that you need to rely on. But moving on from that, to talk about benchmarking, it's worth perhaps tracing the history a little bit. It was in, I think, 2018 that Human Rights Watch published an empirical study of 4 preliminary examinations, which were then ongoing. and made the recommendation that if the Office of the Prosecutor is engaging with national proceedings, it ought to consider publicly identifying benchmarks against which those national proceedings and investigations can be assessed. That, it seems to me, is a thoroughly good idea in terms of transparency and efficiency, which of course are the themes of our side event today. And it was no surprise that those were also ideas picked up in the 2020 Independent Expert Report, which spoke about the need to set up an overall plan for each preliminary examination. And that plan ought to include both meaningful benchmarks and actually, no doubt, to help with transparency and efficiency, giving deadlines to the states involved. So benchmarking is going to be a key feature of this process. And it's important that Counsel are engaged in that. Firstly, to advise at an early stage on what sort of issues might be included as benchmarks, because that is an area where novel and imaginative thinking may be encouraged. Why not include benchmarks for matters such as outreach with victims groups, for example? It's certainly possible to include benchmarks for issues like the provision of training. And I noted that the cooperation agreement with Colombia included the Office of the Prosecutor undertaking to provide training on issues such as the correct interpretation of the Rome Statute. But it's also important to make sure that decisions are taken at an early stage of this benchmarking process. So, for example, if the state wishes to set up new institutions, and that could be something as complicated as trying to set up a truth commission or some form of truth commission, or it could be as narrow as setting up a specialist investigative unit within the National Police Force. But if you're going to do that, it needs to be thought of at an early stage, because then you can include it within the benchmarks, and capacity building measures can quite often form useful benchmarks. And that's useful for the state because them being there in the benchmarks can help to galvanize support both nationally and internationally for that process. But it's also important practically because you can't set up a benchmarking framework with timetables and then say a couple of years down the line, actually, we're going to need to extend all of these because we want to set up new institutions. And finally, of course, Counsel should be involved in the drafting of the benchmarks themselves, because if these are to be useful, they need to be clear, they need to be unambiguous. You don't want to end up in an argument about what they meant years down the line. And they also need to be drafted in such a way that they are possible, so that they're achievable by the state. Because there's no point setting the state up to fail in that way. And that leads me on to the final topic I wanted to touch on, which is evidence. I'll be brief because I think my time is running short, but as a lawyer, I can't avoid saying that at the end of the day, this is a legal process. And one of the consequences of that is that when the prosecutor is deciding whether to open an investigation under Article 53, or even at the later stages where admissibility challenges might be made under Article 17, Article 18, or Article 19, those issues are going to be determined based on the evidence. And it's no exaggeration to say that, taking the example of Colombia again, information was shared with the Office of the Prosecutor on thousands of cases that formed part of the national processes in that situation. And states can expect to have to provide that level of information to the Office of the Prosecutor in the course of these investigations. As counsel, we can make the legal arguments, and there are a lot of legal arguments out there on these issues, many of which remain untested in the ICC's jurisprudence, particularly in relation to Article 18 deferral requests. But what we see so often is that these admissibility issues succeed or fail depending on the quality of the evidence that is put forwards. And in these cases, that evidence, that raw material, is going to be the content of the national investigative files, national court proceedings, and decisions. And so the role of counsel is first advising on how to gather that information and what information to gather. Second, considering how exactly you're going to share that information with the prosecution and potentially more broadly, given that it's likely to be confidential and likely to include sensitive information on ongoing investigations. But perhaps the most important thing for counsel in this whole process is the task of written advocacy that comes from taking that volume of raw material, about potentially hundreds, potentially more than hundreds of cases, and putting it together into a clear submission that explains to the prosecution and to anyone reading it what exactly the current state of national investigations and proceedings are. And that task of written advocacy is probably the most important contribution that counsel can make in advising states at these early stages of proceedings. And I'll leave it there. Thank you.
Thank you, Aidan. Thank you for a fascinating presentation, showing all the different roles that counsel for state can have as soon as PE. And I think for states, even more so than what we heard about victims and defense, there is a very important role for counsels to play. And I'm so happy that we could communicate about that. And that goes from the engagement and all the different benchmarks that you mentioned and the evidence, where we can see that it's the same skill set that we all need. We just needed to adapt to a certain context, because the last example with the written advocacy about evidence, when you'll present an Article 15 communication, it will be the same skill set. You have to adapt it in a different setting. So I think it was very fascinating and very useful for all of us. So last but not least, we'll have Thomas Avov. We're very happy to have you. You started at the ICC as part of the OPCD. Since then, Tom has worked on the defense teams of General Ali, President Kenyatta, Charles Blegude, and currently for Dominic Ongwen. During his tenure at the ICC, he has spent much of his time conducting in-country investigations. And we all really curious about your presentation today about the more pragmatic side of PEs, thanks also to this very important expertise you have about investigations. So without any further ado, Tom, the floor is yours.
Thank you very much, Jennifer. Thank you to everyone coming. And I would like to say, in the words of the Truman Show, good morning, good evening, good afternoon, and good night. I know we're all viewing from different parts of the world, and depending where you're at, the sun may be rising like it is here, or it may be setting 12 time zones away. For my short presentation, I'm going to discuss the importance of building an early case with the practical and logistical problems associated with it. As those listening probably know, generally speaking, the defense and victims do not have much of a right for anything until after a request for a summons or an arrest warrant has been decided upon by the pretrial chambers. It's only at that time where, generally speaking, these important parties and participants of the case receive standing before the pretrial chamber. And so at that point, as you will know from the current active legal aid policy, which hopefully will be changed within the next year or so, victims, according to paragraph 46 or 64, receive approximately 43,752 euros for their entire investigations phase, and defense teams receive 73,006 euros for their investigations. While pursuant to Part 5 of the legal aid policy, these amounts can be increased depending upon need. These amounts are rather small. Now, I mention these amounts because these aren't even applicable to the preliminary examination phase. What can defense and victims do? Now, I know part of this has been discussed by my colleagues before me, but issues that can be done during the preliminary investigation is just getting the word out about it. From conducting in-country investigations in several countries, I know one of the greatest problems in these is the dissemination of false information. People who are not properly identifying themselves, people who claim to work for the ICC or claim to work for organizations related to the ICC, when in fact they're persons down there simply trying to get a contract or trying to collect statements, and some may even have nefarious ideas behind what they are doing. In my experiences, I believe that having outreach, having some sort of meetings between, maybe not in the affected areas, because until there is an arrest warrant which is issued or a summons which is issued, you cannot clearly define any types of the theaters of violence or the areas of conflict in which you are looking. But even in these early preliminary examination phase, the prosecution, they're attempting to do outreach, but their job is to collect evidence and collect information to try to build a case. So why should the victims and the defense teams not be able to do the same thing? Now, I point to one situation. I know that a lot of us at the ICC have seen that, especially when it comes to the confirmation of charges hearings. These have overwhelmingly been pushed back. So the initial date set usually is not the date in which it goes. But I look at the Kenyan cases where you had early involvement with counsels, with persons who were, as Dr. Jacobs said, persons of interest. And their confirmation hearings went on as scheduled, as initially scheduled. They went on within 6 months of the announcement of the summonses to appear. And in my opinion, is due in part because of early investigations and early outreach programs by the defense. Now, in terms of victims, especially why the prosecution is attempting to build its case, having someone there who has met different areas, who has gone to different areas, met different people, they might be invaluable to the office of the prosecutor in terms of allowing them to gain their focus and gain more insight into areas which may be worth investigating. I have talked to several different sets of victims and victims teams, and an issue comes about too, is when sometimes in the prosecution's investigations, they get pigeonholed. They start focusing in on one central area. Now, a proper notification and proper early involvement from victims may actually allow the prosecution to expand its investigation into areas which they may not have looked before and go further back. The court wants to see that victims are rightly compensated and victims are receive their day in court. And if you allow these mere outreach programs, the mere going to talk to people, explaining the process, you can get early involvement, which could also go not only to the, sorry, my son just left for school. You can get early involvement not only from the prosecution, but early involvement from the victims. You also have the problems, the fear of victims being overlooked. These are another issues where the victims themselves, and you see this in situation after situation where they don't understand why certain places are being looked at and their places which they rightfully could be victims are not being there. I've gone on several outreach meetings and where people from different communities who are not part of the affected areas will ask, well, why weren't we informed? Why is there nobody coming to talk to us and to explain to us why we're not doing this? It gets it out and helps the legal process, which is often very foreign to the countries in which we operate. It allows them to understand the process much better. Now, in terms of the logistics, this is a problem. Because of the current legal aid policy, we have no right as if the defense and the victims truly have no right to receive any type of information or any type of monies from the court in order to conduct these outreach. But the court has in its structure the Office of Public Counsel for Defense and the Office of Public Counsel for Victims. In these are the offices which could, if future monies are allocated towards their office to hire additional staff, they could be part of this process where they can go, they can have outreach meetings, discuss stuff with certain affected areas. And if you're with the defense office, you can collect information which may be valuable towards current clients. And if you're the OPCV, it is very similar. You can collect information about potential victims. So the time comes when there is a decision on an arrest warrant pursuant to Article 58, or there is a decision pursuant to Article 58. You don't have to spend the next 3 to 6 months collecting things, finding people representations. The registry can immediately send down lawyers in order to start filling out victim applications. And the defense can immediately start working on information which it wouldn't have had beforehand from the defense office, even if it is just a few names here and there of persons to talk to. Because one of the most distressing things that I have ever heard during an official outreach meeting was in August of 2018 when potential witnesses during an outreach meeting asked me, why weren't you here before? Why didn't we have these meetings with the defense before? We would like to testify on behalf of the defense. And unfortunately, our list of witnesses was due 3 months prior. So getting people out there early, explaining the process, explaining why even the defense have rights. And some people don't understand why victims have rights. And it allows people to understand why victims are being represented, why victims get a voice. And it helps build a stronger and better case for everyone. So we know we go to trial. The evidence itself will be the best possible evidence being presented, not the best possible evidence on a cheap budget. I think my time is up, so I'll let everybody go back to asking their questions now. Thank you.
Thank you so much, Tom, for this presentation and for sharing also with us some really practical information. And I second what you said about trying to be there as soon as possible. I mean, outreach is important, but and sometimes it doesn't get the confirmation of charges hearing started off as fast as you would like, but it does give you an advantage. And to echo what Dov said about the person of interest in the Bagbo case, that was the case. We were there way before it was an ICC case, and it did give us quite some margin of maneuver that we wouldn't have had. It's not always easy. You don't always know what you said, Tom, the locations that they're going to look at, or if who are going to be the suspects in the end. But you can do the best that you can. And I think what we can take from all the presentations from our excellent speakers today is that the good beginning is already half of the work. So that is, it doesn't matter which client you would have, a victim, a potential defendant, or a state. And I think cooperation with the OTP is also something that came out very clearly. And we shouldn't be afraid to engage into cooperation with the OTP. Like I said as an introduction, we often have the impression that the PEs are all about, it's just OTP's business, but it's very clear from all the presentation today that it's there is no good PE without the involvement of counsel. So thank you so much for that. And I will open the floor for questions. So I can see that Jean Flamme has something he wants to share with us. You're muted. We do see you, but we don't hear you yet.
Do you hear me now? Okay. I would like to join the expose of Tom, because he touched crucial items. And it is the item of the legal aid, which is also touching the principle of free choice of counsel. I am a member of the defense section since a few weeks, and I am for the moment working on that item. As far as I could understand, there is some movement going on, and we seem to move to a possible review of the legal system, which is still in force, I believe, since 2013. But if I'm wrong, please do tell me. I have this document in front of me. It's the registry single policy document on the court's legal aid system. I have practiced in the first case before the ICC, which was the Lubanga case. In a way, I was the only attorney in the building at that time. And I think I had to teach the registry what defense was about. And I'm surprised to find that the registry at this time still doesn't seem to understand what defense is about and what an attorney is about. Let me explain this in a few items. First of all, the principle which was in force at the time was equality of arms. So this means that a counsel should be on the same financial level as a senior officer at the prosecutor's office, which is, of course, absolutely right. But when I see, and I will speak about the figures for briefly, that the registry estimates that departing from a gross amount of 10,832 euros gross revenue, it comes to, I don't know how, a net amount of 8,221 euros. I don't understand this calculation. Secondly, the registry says, because that is also crucial, the tax impositions and the social security impositions, which differ from country to country. To give one example I know very well, cumulated in Belgium, this means at least 65% of the gross income. That would reduce the earnings, the monthly earnings of counsel for Belgium to 3,791.2 euros. Now, this is absolutely ridiculous. I'm sorry to say this. Who are we? How are we considered? This is not even what a law firm in Belgium has to pay to a first-year intern. Now, the thing is that the standards of the court are very high, and rightly so. These cases are extremely complicated. If you accept the defense, you have to accept that you can be busy with just one case full-time for years.
Excuse me, sorry to interrupt. I'm abusing my position as a panelist, but these are crucial questions which the ICCBA is dealing with and will continue to deal with. But we have about 13 minutes left on the panel, and I see hands raised to actually discuss the issue of preliminary examinations. So I'm not sure this important question will be solved in this particular side event. So I'm wondering if
but if
we should not continue.
If you let me speak 1 or 2 minutes more, I will have finished. Okay.
Thank you to both of you. Yes, Jean-Flamme, please, if you could wrap it up in 1 minute. Thank you so much for sharing your experience. And as you noticed, this is one of the priorities of the ICCBA, and we've been working on these terrible working conditions we're in. So we'll give you an extra minute. and then we'll have to wrap it up because we have less than 50 minutes to answer questions, and then we'll have to wrap up.
Enter from the very beginning an action plan. Counsel should never be demanded to reveal their defense strategy. It is violating confidentiality. And more than that, the action plan and the actions at the end have to be approved by the registry, which withholds, I think, 25% of the earnings of counsel up to the end of the, for example, pre-trial phase and trial phase. This is not acceptable. Who are we for these people? Thank you.
Thank you so much. Thank you so much for this. Do we have any questions for the panelists? I had seen some hands up, but I'm afraid that some of them went down. I see a hand up of Annie O'Reilly, please.
Hi, I'll turn on my camera. So I used to work on preliminary examinations. I did 3 years in that office. I'm not there anymore. I'm not speaking on their behalf. Caveat, caveat, caveat. But I just wanted to say a few things, sort of just about the overall kind of how we do PEs or how we did them when I was there. I think Tom had said something about information to build a case during a preliminary examination, and that was very much not my experience. We were definitely not trying to build cases. We were really only in the business of testing the information that we were receiving, regardless of the source that it came from. You know, so I would, you know, quite often do an analysis of an incident or whatever and come to the conclusion that there was no crime there, you know, and then that would not be included within the subject matter. Now, it's always possible that in the investigation more information will come to light to determine that there was a crime there. But I just wanted to clarify that it is a much more, while it is part of the office, it is a much more objective role than in, say, the prosecution division or the investigation division, where you are actually trying to build a case. And then just something that Dove had said about getting information from potential suspects. I mean, I think it's kind of interesting. The problem that we always had was, you know, how do you put parameters over seeking information from people? And like I said, we're really just kind of trying to judge the information that comes into you. If you reach out to, I don't know, the commander of the brigade and they give, say, their information, but then in the investigation you end up going after somebody lower down, I mean, it causes all sorts of issues, and issues for trial as well, and for the objectivity of the process. And I mean, that goes as well for speaking to victims and victims representatives. Like, where do you draw the line in terms of that external sort of, you know, reaching out for information as opposed to just kind of receiving what's coming in? And I'd be interested to hear if anybody has any thoughts on like how to regulate that, or whether even people think that is a problem in terms of the information that is going into the PE pot. Thanks.
Thank you. Dove, do you want maybe to take this one? As I have the feeling it's more a question on your presentation, or maybe Heidi as well, because victims were mentioned.
Heidi, I'm happy for you to go first.
No, I certainly understand that it is what's coming into the office of the prosecutor that's being evaluated. I think the comments I was making aimed just as the fact that for victims, what's going to be evaluated is what the prosecution has before it, because it's not going to go out and seek that information from potential victims, particularly during that early phase of preliminary examinations. So of course, I'm speaking on the behalf of victims' counsel, so you're always going to advocate for your client's interest and do what you can to make sure that victims are highlighted. And that's a different role than what the prosecution plays. So my comments and my suggestions are aimed at making sure that victims' circumstances, the facts of their cases are highlighted. So what I had suggested was promoting giving that information and contributing it to that pot that Annie referred to. Yeah, so I'll finish with that. Doug, did you have anything you wanted to add?
No, Annie, I take in your comments rather than questions, and I agree that especially on the question of contacting potential accused, as I said, it's a case-by-case evaluation. I don't pretend that it's an easy framework to put in place and that there should be systematic or that there can be a systematic. It will really depend on the circumstances of each particular preliminary examination. But what I was starting with is the state of mind. In some situations, clearly the state of mind was not one of getting both sides of the story, and we won't go into the details here. So if it materializes into actually contacting certain individuals to get their side of the story, if it's more state of mind and investigating, exonerating evidence, which might be related to persons of interest, then again, a case by case. But actually, I'm going to put you, Jennifer, on the spot, because you have a perfect example, which we use in the article on the issue in the Gabon situation of how this can work out in a constructive way. So I'll kick the ball down to you.
Thank you. Well, I was going to volunteer to share also a little bit of my insight to answer Annie's comments and questions. And I'll take the Gabon example as an opposition to the Gbagbo situation. As Dov said, it's a case-by-case basis. And I actually believe that if we would put into place protocols or systematic approaches, that would be counterproductive and somewhere counterintuitive, because each case is different. And that's how we start off building cases. Doesn't matter which side of the bar we are. In the Gbagbo case, there was no two sides that were being investigated. The investigation had lasted very short time. The prosecutor went on record saying there was going to be a bad ending, and so it was very clear who was the target of the investigation when it started. And at that time was the PE. It went so fast. It went PE. There was already investigations going, but not at all into what happened. Ivory Coast was not a state party. Well, so I won't go into the details of that. But the suspect was very clear, and that suspect already had a lawyer that was on the list of counsel and was engaging with the office of the prosecutor, and the office of the prosecution was not interested. Whereas in the Gabon situation, we had exactly the opposite. It was a situation where there has been a recent referral of Gabon, and I intervened as counsel for victims and political opponents, amongst whom Jean Ping. And so we filed an Article 15 communication, and we had meetings with the OTP to discuss that Article 15 communication. And at the end of the day, it was decided to not pursue the PE because there was not enough evidence after the referral of the Gabon state, who wanted to make an example out of it and target Jean Ping. So it was very interesting that when the OTP actually for NGOs, and there was an actual result. So therefore, I don't know if this answers your question, but I hope that these two examples show that engaging with counsels in different capacities can be beneficial. And at the end of the day, it is up to the OTP still to decide what they want to do with that information. But if they go and fetch information, they can the problems that you mentioned about what do we do with this information for a fair trial. We are all professional lawyers. We have a code of ethics. We know what kind of evidence we can use and not, and how to use it. So that's what I would add.
If I could just say one further thing that came to mind from Annie's comments and question. It's a bit off topic with it, but Annie had said that during the preliminary examination with the OTP that there are instances where they do assess the evidence that's before them and make a decision that a crime wasn't committed. And, as I talked about in my remarks about the length of the proceedings, when it comes to victim representation, it's really important to remember that counsel for victim often are not only representing victims at the ICC. This is a lengthy procedure. There's a good chance that victims, the particular crimes that they suffer might not be included in the end after years of engaging and participating. So for counsel, it's very important to also look into what other options domestically or internationally are available to victims, whether it's human rights remedies applying to the UN or other human rights bodies to get a resolution or some kind of finding on whether human rights were violated for these victims, or if it's civil remedies, multiple different things, or universal jurisdiction. There's so many other options that are important because the individuals that we represent as victims counsel are not just victims at the ICC, they're your clients, and you have a duty to look at all the different ways that you can assist them in finding justice. So what's so important, I just want to bring it back to our discussion about the importance of the role of counsel and for victims, is that as we're looking at all of this, the scope of the way that they can be represented at the ICC and in other jurisdictions, it's so important for victims to get advice about all of their options and how they're going to interplay, how the evidence or the decision from a human rights body could be used to give back to the prosecution to help with the evidence that's coming into the prosecution, and also to make sure that all of these efforts that build that pressure towards getting justice for victims are complementary to each other and are supportive of each other. And that's something that's so important for counsel to be able to do for victims. So I just wanted to add that one bit.
Thank you, Heidi. And I mean, I don't see any hands up, and we are coming towards the end of our time. But I would, if there is no other hand coming up, I will use that just to say that what you said echoes actually all the presentations, because it doesn't matter if your client is a potential suspect, a state, or a victim. At the end of the day, it's good that we're reminded that we have to act in the best interest of our clients, and now we have discussed means to do that. In taking the ICC into account, but maybe not always being the end game. And I think that's quite important to keep in mind as well. We're international lawyers acting in international settings, but we have different tools at our disposal, and we should not forget about that. Aidan also talked about truth and reconciliation commission, for example, and things like that. So we have these different, we are versatile in our practice, and we need to use all these tools. I do see, Abigail, you have your hand up. We'll take a few extra minutes to get your question, and then we'll wrap it up.
Yeah, thank you, Jennifer, and I'll come on briefly. Thank you for this great presentation. My question was going to Aidan, and I think it's a broader question for the next few minutes, but I wanted to get clarification. When he talks about counsel for states, is he thinking about it separate from the frameworks where government officials, say attorney generals or solicitor generals, are working on behalf of their governments? And secondly, that framework that he briefly mentioned, I would have loved to hear more on how he thinks. That would cover concerns of bias, of witness interference with prosecution investigations to get the best evidence out, considering that most of the situations we've seen, the other parties, typically government agencies. So I would have loved to hear more of that, but I understand we don't have as much time. Thank you.
Thank you for your question, and very interesting. Aidan, are you still with us?
I am still with us, and just remembering to unmute myself. I think if I were to give a full answer, we would be here for quite a long time. I was thinking of in answer to the first question, my remarks were very much at the idea of external counsel providing advice that feeds into the advice that states are already getting from their internal frameworks of attorney generals and the internal legal advice. I think it's common in these sort of situations for there to be a team of lawyers involved. And part of the skill for external counsel is in working together with those people who bring their own perspectives to it. But there is still definitely something that counsel experienced in ICC proceedings can bring to the discussion that's perhaps a little different from what the attorney generals will be providing themselves. As to the second part of the question, it seems to me that those are all valid points that should be part of the benchmarking discussion. They're all things that are capable of being included in discussions between the Office of the Prosecutor and the states. And it's important that at the beginning, the discussion's as broad as possible, and that what emerges as benchmarks is a distillation of the concerns that are raised at the earlier stages. I'm not sure that's a full answer, but it's as full an answer as I can give briefly, I think.
Thank you, Aidan, and thank you all of you to have joined our side event and for your comments and for listening to us. I hope it was as interesting for you as it was for me. I still learned a lot of new things and new tools that I can explore further. So thank you to our speakers for that. And we hope to see you soon because the ICCBA will have a lot of new events coming up in 2022 already. But in the meantime, please try to, in these difficult times that we are facing, still enjoy your loved ones and the holiday seasons coming up. Thank you so much.